I'll start again. Good evening and welcome to What Journalists Need to Know About the First Amendment, presented by the Valley of the Sun chapter of the Society of Professional Journalists, or SPJ. Thank you for tuning in. I'm Mark Scarp, a member of the chapter board and your moderator. Our president, Tim Igo, will be assisting me this evening. Tonight's discussion, which will last about 1 hour, will be recorded. It will be posted at a later date on the Phoenix SPJ chapter website, which is Phoenix SPJ, spelled out all one word, phoenixspj.org. Everyone who registered to attend will receive notice after this is over when it's to be posted, and we encourage you to share it with your colleagues. Only the panelists will be able to be heard tonight. Everyone else is muted, but we encourage you to please put questions into the chat. Tim will select questions for our panelists to answer as time permits at the end of the session. We thank our panelists for their time this evening. Peter Lim Paris practices at the Tucson law firm of Miller, Pitt, Feldman, and McAnally. Peter also is counsel to the First Amendment Coalition of Arizona. He graduated from the University of Arizona College of Law. Taylor Seeley covers First Amendment issues for the Arizona Republic and azcentral.com. She graduated from ASU's Walter Cronkite School of Journalism and Mass Communication. So if our panelists are ready, let's begin. Peter, why don't we just start out with the big question? Who does the First Amendment protect us from, and who doesn't it protect us from?
So that is a big question, and let me give you a sort of a little outline of what I'm hoping we'll have time to talk about today, and that's what Mark just mentioned is the first thing we're going to talk about, which is who does the First Amendment protect you from? From there, we'll move into the idea of whether journalists have more of a First Amendment protection as opposed to an average citizen. We'll then go into talking about something that impacts journalists, of course, all the time in terms of what they're going to either publish on television or in a newspaper, and that is defamation, libel, the types of pitfalls, the protections you have, and so on. From there, I want to talk a little bit about just the practical effects of dealing with a libel claim that's being asserted or being threatened against a station newspaper. And then also a little bit about the types of special protections you do have. We'll get into the shield law briefly, as well as the Arizona subpoena statute that helps protect you in case you're subpoenaed. Then Mark had also mentioned maybe talking a little bit about copyright law, specifically as it applies modernly to photographs, whether it be on Facebook or other social media. And then sort of the last section is talking a little bit about both getting into places, whether it be the courtroom or open meetings. And then I hope to have quite a bit of time to talk about public record and obtaining public records. That's an issue that I have found certainly in the last 10 to 15 years has really been on the forefront in terms of answering and helping journalists in Arizona. That's a very frequent question and concern I get is, geez, we're not getting public records. So that gives you sort of a little bit of an idea of the types of things I'm hoping to talk about today. So let's get back to the first one, which Mark talked about, which is who does the First Amendment protect you from? And I think the real key is it's a protection from the government. It's not a protection from your private employer, for example. So a common example I'll give to folks is someone that works for, let's say, Best Buy, and he's upset about how his supervisor's been treating him. That night, he goes on Facebook and talks about how his direct supervisor is incompetent and a problem and doesn't do his job. And Best Buy has a policy about not providing information about employees publicly, and he's fired. And he says, geez, you can't do that. It's protected speech. And the answer is, no, it's not. The government can't restrict your speech in a situation like that if he was working for a governmental employee. But it doesn't protect individuals from private individuals or private entities as a general matter. So you can be censored by those private organizations. You can be censored by those types of individuals. Another quick example would be the difference between a public school that's publicly funded versus a private school, and the same sort of difference would apply. So just remember that the First Amendment in this aspect restrains government actors, and that goes from federal to state to local. So that kind of segues into, well, I have journalists often, well, don't I have special privileges? Don't I have special rules that apply to me in terms of the First Amendment that don't apply to the average citizen? Generally, the answer is no. There are some little caveats, and I mentioned them a bit ago, and we'll get into them later, which is shield laws, media subpoena laws, and that sort of thing. So we will talk about that. But the general answer is no, there aren't a whole bunch of special privileges or protections. Taylor, do you have any experience sort of in your work as far as this goes?
Well, I think the interesting part when we, talk about whether reporters have special privileges is just sort of that distinction between reporting. Journalism has that kind of sort of special privilege in the Constitution, but not necessarily reporters. So I think about the case of the Gateway pundit who was blocked access to an in-person election related press conference in 2022. Can't remember the year, but he had been blocked access, and eventually that was actually struck down as unconstitutional on First Amendment grounds because everyone enjoys press freedoms equally. And I think that is a positive thing because at the end of the day, you do not necessarily want the government to be able to declare who is and is not a journalist, who does have these privileges and who doesn't. So it's reporting that has that kind of special protection, but essentially anyone can be a reporter.
So another area that is very frequent that I deal with journalists, again, whether television or in print, is I'll get a phone call. Hey, can you look at this script? Can you look at this package? Can we say the following? And of course, that's the concern of libel, defamation. And so what I would like to do is, we could spend easily a seminar of a day or two talking about defamation, but there are a lot of the main points that I think we can talk about. And it's always good to have a refresher on these. I know that all of you probably know quite a bit of this, but a refresher really never hurts. So the main parts of what defamation, what libel is, it's a statement of fact, not opinion, that is concerning an identifiable plaintiff, that's published to a third party. I mean, you can't defame somebody by just telling them and them alone. That causes some kind of reputational harm, reputational injury, where you're at least negligent. And we'll talk about that later. There's, in some instances, you can be more than negligent, but in oftentimes it's going to be a negligence standard. Really important. I can't tell you how many times over the last almost 30 years I've heard a reporter tell me, hey, well, it should be okay, I think, because I just repeated what someone else said. I know it sounds like what the other person said is defamatory or libelous, but we just repeated it, so we're okay. And that's a false assumption. The repeater of the defamation, the republisher of the defamatory statement, can be just as liable as the person who said it originally.
Peter, I have a question for you actually on that. So then as a journalist, if you feel like there's a real newsworthy reason to report something that someone else is saying and you aren't sure if it's true or not, can you protect yourself by simply inserting some sort of line that says something to the effect of, the Arizona Republic or whatever publisher that you're working for could not independently verify this? How does that affect it?
So that's helpful. The other thing that's even more helpful is investigating it yourself, because if you're ever on the witness stand in a trial and I say, Ms. Johnson, what steps did you take before republishing this to determine its veracity? Well, we called so-and-so, we did so-and-so, we did this, and we also said on air, as you just stated. That's really helpful. Anything that can help show that you did not simply take it and boom, just republish it. So yes, that it's certainly helpful. Story balance is also not a defense to defamation or libel. What does that mean? It means that you can't call up the station lawyer and say, this happened, we said this defamatory thing, but we also gave everyone the other side of the story. So are we okay? And the general answer is no. Story balance is not a defense to the part of the story that's defamatory. Story balance, of course, is great from a journalistic perspective. It's something to strive for, but it's not a defense. So a defamatory statement has to be false, obviously, and we'll talk about what truth is in a minute. And you have to look at the package or the article as a whole. That means you look at the headlines, you look at photos, you look at captions, even omissions can create liability for defamation. The real important part is, what is a statement of fact versus what is an opinion? And it's actually, in most circumstances, relatively easy to figure it out. You do have to look at the type of language that's used. You have to look at the tenor and the susceptibility of whether something can be proven to be true or false. So many of you are probably too young to remember this. There was a guy on 60 Minutes.
Andy Rooney.
Andy Rooney. And he was a real character. And often Andy would get on in the last few minutes and, he'd have some, gizmo, as he would call it. And Andy said, this electronic gizmo doesn't work. That's probably a statement of fact because it's provable to be true or false. Go ahead.
It was a locally made product. It was one made here in Arizona. It was called Rain-X. It was a type of windshield wiper that they claimed cleaned windshields better than anybody, bar none.
Yeah, it was actually a hydrophobic product where
yes,
it was supposed to beat off the water so you would never have to worry about your windshield getting fogged.
That's right. You poured it on or something. That's it. And he claimed that he didn't see any difference between just letting nature do it.
See, now, if that's all he had said, I don't see a difference, that would have been different. But he basically said it didn't work.
Didn't work.
For its intended purpose. Another example of something that would be an opinion, law enforcement is called to a elementary school. There's some kind of issue with students. The law enforcement officer comes in, he interviews students and some staff members. Nurse that's standing there comments to her colleagues after the officer leaves that he was rude and disrespectful. Officer finds out about it and sues the nurse. He's not going to get anywhere with that. And the reason is it's not provable to be a true or false whether he was rude or disrespectful. That's her opinion about what his behavior was. A defamatory statement has to be about somebody that we can identify, that the reasonable viewer or reader can identify. It must be an ascertainable person. And so you can't, Oprah Winfrey got into some hot water with talking about, it was mad cow disease and a bunch of ranchers got together. And the idea is you can't have sort of this group libel concept. So if someone publishes a statement that says all the lawyers in Tucson are stealing money from their clients. I'm a lawyer in Tucson, but I don't have a lawsuit because I'm not an ascertainable plaintiff in that particular instance. Now, as you narrow that group, you start getting closer to it being an ascertainable person. If you say all lawyers at firm X and firm X has 6 lawyers, now you probably have a problem. So it's got to be something that's identifiable in terms of the plaintiff. Truth is actually fairly easy. It's not absolute truth, it's substantial truth. And substantial truth is a complete defense. So minor inaccuracies, you should try to avoid them, of course, but minor inaccuracies don't defeat the truth defense. You just have to be mostly right on the important stuff. That's really kind of the everyday sort of practical test. you do have some privileges when it comes to official proceedings. So if you are a reporter and you fairly and accurately report something from an official proceeding, you have a privilege to do that. And so you're going to have a protection there if you're publishing directly from there. Fair and accurate summaries of documents, so judicial documents, legislative documents, and other administrative documents and proceedings is also protected. There are some conditional privileges. We don't have time to go through many, but conditional is different because conditional privileges can be defeated if it's shown that you had some knowledge of the falsity or recklessly disregarded it. And that would be more like fair and accurate reporting of public proceedings or statements in like public records, for example, instead of official records. There are some constitutional privileges, and these are the ones that you've almost certainly heard about because they're really, really important when it comes to what you're considering publishing or putting out in a package. And that is public officials and figures, as opposed to the average person, have to prove up actual malice, that you acted with actual malice. That means knowing what you were publishing is false or being in reckless disregard. So it's a very high standard, and it's reckless disregard is basically it's like having serious doubts about something. You don't have to know it's false, but you have really serious doubts about what you're publishing. That's generally what reckless disregard is. The place to be super careful, and when stations and newspapers get sued, it can happen here because the standard's very different, is when there's a story about an average person. It's not a public official or a public figure of some kind. It's an average Joe Schmo, and negligence is the standard there. Much easier to prove up than actual malice. So that's where journalists can get in real trouble because the standard is so different. So another call I get, and these are the ones I don't really like to get, is so-and-so called us. He's threatening to sue us for what we published. What do we do? I talked to him for a long time, and I told him, we would definitely retract everything we said. I, say, stop, don't, that's not how you do it. So how you handle a libel claim is really good journalism and good professionalism. Always be polite. It can be difficult, I know. I've heard some of those calls, and some folks can be pretty irate and upset, but being polite to the person that's on the phone is remarkable how often that can really disarm the person and stop a problem from ever becoming a bigger problem. It's always a great thing to say, hey, we're journalists. We absolutely will check our facts again on this. I really appreciate you calling or writing us or emailing us, but don't admit errors, particularly without knowing more. Just say, absolutely, we're going to look into this. We'd be happy to. Never admit or volunteer that, oh, I'm so sorry, you're right. This is how the mistake occurred. It's always important to evaluate it before you say anything, before the station says anything, before a manager says anything, to really evaluate things. And then, of course, telling a manager, telling a director is always important. I tend to think that it's better to say, if it does come out that an error has been made, a mistake has been made, to really to issue some kind of clarification. I would only use full-on retractions for something that is really extreme. I mean, and absolutely, you got it completely, totally wrong. So I would really sequester a retraction in those extreme cases, and otherwise I would just make a clarification.
I just want to remind everybody to please put any questions you have into the chat. So we will get to them. I just wanted to remind everyone that you can do that, please. Thank you, Peter. I'm sorry.
Yeah, sure, no problem. Taylor, do you have anything that has happened or any suggestions you might have on just sort of on the ground how to deal with libel claims?
Well, like you were discussing the actual malice standard for public officials and negligence for, kind of those non-public officials. I think that the best thing, like you said, is just good journalism, which, I think every journalist is hopefully doing nonetheless. But if not, just sending an email, making a call before you publish, and ideally a couple times to just say, hey, we're going to be moving forward. If you would like to, comment, or, this is kind of what, obviously, you're not sharing your entire story, but these are the specific facts that we're stating in the story. If you have any corrections, please let me know, or please let me know by, this date and time. Because Peter, correct me if I'm wrong, but that's going to help if, heaven forbid, there is a claim made and it goes to court. You can then say, well, clearly there's no malice here. We tried to reach out. We were trying multiple times. We did our due diligence to get everything correctly, right?
Yeah, and it makes, if I'm the lawyer defending that case, it makes my job so much easier because it humanizes it. This is someone that went out of their way to try to fix this. You get to show the jury, look what they did in the same time slot. The next night they did this. You get to get it up on the screen, and that really can diffuse sort of how activated or otherwise upset a jury might be in that scenario.
And then I have a question for you on clarifications versus retractions. What about, corrections? Like, because if it does turn out that you made a mistake as a reporter, we all do, and there is an inaccuracy in the story, do you still at that point recommend clarifications on the story, or is it okay to at that point say we're issuing a formal correction? This wasn't formerly inaccurate in our story. How do you feel about that?
I tend to just prefer clarification.
Gotcha.
I guess it's semantics at some point. And it's really more important what you're doing as opposed to what you call it. I just don't like, I definitely don't like journalists talking or stations talking about a retraction, except in those extreme cases where there's no choice. It has to be a retraction. Otherwise, I tend to try to keep it simple and say that we're trying to clarify what happened last night. And it's important to do it in the same, if it's on air, you can't bury it, right? If it was the lead story the night before at 10, you can't have the clarification on, at 10:27 the next night. It's got to be in the same, essentially the same type of slot. So that moves us into a couple statutes, which I'll mention briefly, which are really good statutes to take a look at yourself if you haven't already. The first one's sort of the Shield state statute, which is 122237. And that is more or less keeping you from having to testify about this is the person that's the source on my story. The one that comes up a lot is 122214, and that's the media subpoena law. And so probably a fair number of you have been served with a media subpoena asking for, your file, your notes, all these sorts of things. And the good news is that it's actually pretty difficult to get those materials from a journalist under that statute. The other good news, candidly, is most lawyers don't know this statute. Probably 85% of the time when I have a journalist call me up and say they have a subpoena, it not only doesn't mention 2214, it doesn't comply on its face. And if it doesn't comply on its face, the lawyer can write back a letter to subpoenaing parties telling them that because it fails on its face, it has no force and effect, and we're not doing anything. So 2214 is really worth a read. It's pretty easy to understand, and it's really important. It's going to help protect you and probably calm you down when you get a subpoena, because you're going to realize that it's probably going to be okay when I report this upstairs and when the lawyers get involved. If you get one of those subpoenas, that's exactly what I would do. I always tell journalists, tell the news director, tell whoever your supervisor is right away, hand it off to them, because 9 times out of 10, they're going to call the paper's lawyer or the station's lawyer to deal with it. And it's usually relatively easy to deal with. It's been in almost 30 years. I don't recall a time where I had to have them produce something. Copyright. So this is probably the second most common call that I get. Somewhat surprisingly, because the rules are relatively straightforward, but it's using social media photos. So this hasn't been around too long, so I guess a couple of decades, but you can't take a photo from Facebook, from somebody's Facebook page, and just say credit, Peter Limperis, and think everything's fine. It's not. That's a violation of copyright. The second you hit your little shutter button, whether it's on your phone, or some of you might even remember real cameras, DSLRs or film cameras, when you hit that shutter button, you've done something, and that is you own it. It's your copyright. You don't have to get it copyrighted over at the Copyright Office, although that can help you get additional damages. Journalists will say, well, I think it's fair use, and we can't get into that in detail just because of time, but fair use is far more narrow than I think most journalists think it is. And the rules for copyright with photos are pretty simple. You either need to get a license from the person, or at a bare minimum, some kind of email, something in writing. Phone call is not good enough. Something in writing saying, here's this photo. Yes, you can use it. You have my permission. I license it to you. Something like that. That's critical, because that comes up all the time. And it can be a very expensive problem. So that gets us into sort of the getting into places section, which is public places, facilities, and everyone has some interest or rights, but journalists don't really have any different rights, generally speaking, from the public. And I think Taylor maybe even alluded to that or mentioned it earlier. Private property is the one actually that I do get a fair number of calls on that. We want to do this story about this homeowners association. It's a gated community. We're going to wait. Is it okay? We're going to wait for somebody to go in and, sort of follow them in. And like, well, no, that's not a great idea. That can be trespass. So, trespass is one of those things where if someone asks you to leave and it's a private area, better to leave, because if you don't, someone like me has to show up and get you out of jail. Taylor, do you have any sort of experiences in this, or?
Yeah, I think the one that comes to mind for me is actually so it's interesting because, we were talking about how reporters do not have any like special privileges. I think when it comes to accessing public places that everyone has a right to be, that's actually where reporters can be sort of limited, where sometimes you get, whether it be government officials or contractors who look at reporters and think, oh, you're a reporter, so you can't be here for whatever reason. So I think about last summer, the city of Phoenix began these overnight heat relief centers. And one of them was at the actual city of Phoenix Burton Bar Library, a public place. Everyone can go. Literally every single person has a right to go there, even overnight. And so I went and attended these heat relief centers to see how they were operating. There had been some serious concerns over safety and crime. So I went to go check it out. And as soon as I enter, the contractors, kind of their shoulders go up and they're like, oh, actually, you can't be here. And I was like, what do you mean? And they were like, well, it just, this is for members of the public, and, you're a member of the press. And I was like, yes, I'm a member of the press, which is a member of the public as well. And it turned into this, whole ordeal. And I think the important thing is, obviously, like we stressed, you have to remain very calm and polite. But to somewhat, still stand your ground and just say, hey, when for sure, like I did, that this is a library where you cannot kick me out for being here, to just say, hey, I am very confident that I'm allowed to be here. This is a place where anyone could go. I'm a reporter right now, but I could also just have a broken air conditioning in my house or my newsroom, and I want to come off and cool off here. So just kind of stating that clearly. And then I think, to the extent that you can, what I had to do in this scenario was actually reach out to the city of Phoenix and their media persons, public information officers who typically understand these rules a little bit better, to have them kind of on speed dial to be able to give the contractors a call. In my experience, it's usually government contractors who don't understand the rules. Every once in a while, it'll be an elected official. So if you can shore up your relationships with another person at that location or at that government institution, it's very helpful. But again, just places where you're 100% sure you're allowed to be, stand your ground. A number of reporters had just turned around and left before I was like, wait, hold on here. So
Yeah,
that's
and I
my
mean,
advice.
you handled that perfectly, obviously. I think I see it sometimes with law enforcement, um, which also really troubles me. And the story you just told me is very troubling. Law enforcement, it happens too, where we get, obviously, no member of the public or reporter can interfere with some, for example, emergency proceeding with law enforcement and, the ER person, the medical personnel coming in. But I have seen and heard law enforcement officers say, oh, the public can be here, but you journalists have to be back there. And that, of course, is outrageous. And those are the types of things that just we can't let those let them get away with those sorts of things. So if they, with law enforcement, that can be intimidating, of course. But at a minimum, getting someone on the phone, whether it's attorney for the station or the paper or a director or a manager, to really push back on that sort of behavior, because it's intolerable.
And I do think that a way to push back there, I think unfortunately reporters are often too afraid to report on themselves. We never want to be the story, of course, but when it comes to reporters being barred access to places that they should absolutely have a right to be, there is an accountability angle there, and I think that should be reported. And I've actually been very surprised and heartened to see in covering First Amendment stories how much the public actually does care when journalists are barred entry. Months ago we had a story come out about Fountain Hills, and that council was really vehemently opposed to some coverage from a hyper-local paper. And so they took the media table away. Now, technically speaking, this was okay because the reporter was still allowed. They just had to sit kind of with all the rest of the people, and they didn't get their own special table. The reporter himself did not care one bit. But I reported on this story as sort of antithetical to the values of free speech and the protections for press. And I, again, was just like floored at how many people read the story, how many people were really alarmed by it. So I would just encourage journalists to not discount reporting on instances when actually journalists are barred entry or prohibited from information that they should absolutely have a right to.
And I think, we can probably talk about open meeting laws a little bit as well. And this is also statutory, it's 431 to 431.09. I get these calls not frequently, but it does happen. I can remember one maybe about a year and a half ago, where someone's having difficulty getting into a public meeting. And, there's a presumption that all of these meetings are open to the public. It's a public body. Assuming it's actually a meeting. Occasionally there are issues as to whether or not it is a meeting. Whether it's a meeting or not can be a little tricky sometimes, but the basics are, either everyone gathering physically, but also nowadays what we're doing right now, which is video conferencing. That counts too. And so that's important as well, to see if there's a quorum in a meeting, whether it's by video or otherwise. Public bodies are pretty straightforward. It's also defined in the statutes, but that's, essentially every kind of public entity, advisory committees, subcommittees, most of these will count. Very rarely, although these are fascinating, I'll have a reporter in a meeting, in an open meeting, and an so-called executive session is called, right? Where everyone disappears and talks about something secret. And of course, everyone's excluded. But it's important to remember that, you got to watch, keep your wits about you. Was the executive session called properly? What were the, stated reasons? Because at times executive sessions will be improper. And so that can be an issue and something that I think is interesting. What do you do when you're excluded from a public meeting? I think as Taylor mentioned, I mean, you can always get nervous, right? If somebody's telling you they know what they're talking about and you can't be here, whether it's in the tent or whether it's at a public meeting. Again, good journalism. Can you explain to me, please, why the meeting is either being closed to me or to everyone? Is it going to be recorded? I'm not going to volunteer to leave. Are you directing me to leave? There's a difference. Are they asking you to leave or are they directing you to leave? If an executive session is called and you have some doubts about whether or not it's permissible, ask questions. What's the stated reason for the executive session? There's nothing wrong with doing that, and asking questions is often important. Of course, when someone like me gets involved, it's because a journalist is in a meeting, they call their news director or manager, and they say, hey, we don't think this is right. What's happening. So always making those calls, asking questions, using good journalism is really going to help you out. Tell you're not. So what do you?
Yeah. And to that point, e-session is something that on a personal level has driven me crazy as a reporter because just different municipalities handle it really differently. So like a one reporter pitch here to all my fellow reporters is I think we should all be paying attention more to how our different local governments are calling for their e-session. You know, typically I had covered city halls for about 5 years, and it was almost the same all the time where they'd say, okay, we're going to vote to go into e-session right now. Does everyone say yes? Yes, they'd leave the room. So you kind of knew when they were doing it. And then you also typically saw them come back in the room. This didn't reveal a lot of information, but you had the agenda where it was supposed to lay out, at least the bare bones kind of topics they were discussing. You saw them go into the room, you saw them exit the room, so you knew roughly how long they were talking. It doesn't give you much, but it gives you something. Now, interestingly, there are some cities, City of Phoenix is one, where they have this new, maybe I shouldn't say newer, relatively speaking, process of bulk approving their schedule for the year. So in, I think, January, they say, we're going to go into e-session 20 times this year on these dates, and they approve it ahead of time. And then the day before those dates, they put their agenda out. The complication as a reporter and transparency in this is that it's really hard to remember, 6 months ago, the council said they were going to go into e-session on this day, and I have to put a reminder in my phone or my calendar to check the agenda 24 hours before. So I just put a pitch to reporters to pay attention and find out if your local government does it in that way, where it's a bulk approval, because you do literally need to put reminders in your calendar to then go search the agendas. Another thing is that when I was reporting on that open meeting law process in Phoenix, because there was a resident who was asking serious questions about it, and enough to where he had filed a complaint to the Attorney General's office, the Attorney General, Chris Mays, actually came out with a letter essentially saying the municipalities should try to be as transparent as they can be with the agendas. And so I mention this just to call on you and encourage you as reporters to ask your institutions, if you don't feel like this agenda gives you any sense whatsoever of what they're discussing, it's not going to hurt to say, hey, I know you can't divulge confidential information, but is there anything more you can say about this that can explain it so that we just have some understanding? And I think that it would probably bode well to point to the Attorney General's letter saying municipalities should try to be transparent where they can in agendizing executive sessions.
So many decades ago, this now goes to getting into the courtroom in terms of, it usually comes up with cameras in the courtroom. Things were pretty dim and dire because a judge basically could just say, nope, don't want the cameras in the courtroom. and it was very difficult. It still can be difficult, but there's a rule that applies in these situations now, which I'm sure most of you are familiar with, which is Rule 122. And here's the 122 talks about what you need to do if you want to have recording devices in a court proceeding. So a couple big things that make it easy for a judge to say no. If a judge is sort of itching to not want to have cameras for whatever particular reason, the really easy way out is for you to miss the deadlines. I mean, it really is an easy way out for judges. So please don't miss the deadlines. If it's for a trial, you got to go 7 days out. If it's for basically anything else, a hearing, any other kind of proceeding, it's 48 hours. Don't miss those deadlines. That's really important. Anybody can object, right? Just about. So you put in your request under the rule, and usually it's going to be, not always, but usually it's going to be a defense lawyer. Sometimes it's going to be a witness that might object, but usually it's going to be a defense lawyer. And if the objection's made, then there needs to be a hearing. And at those hearings, and Rule 122 lays out these 7 factors, which I'll talk to you about in a second. Some of them are pretty easy to satisfy, some are not. The judge has to listen to actual evidence, not just argument. Actual evidence about whether or not, let's say it's a camera, whether a video camera would somehow impact there being a fair trial, somehow impact there being a fair hearing, assuming it's a hearing. Would it have some privacy problem, right of privacy issue, where even though this is a public proceeding, is there some interesting or strange or different reason why there might be a privacy issue? Here's another important one, and a lot of times judges will take this one very seriously. Is there some safety issue about a particular witness, for example, that putting this person on air as opposed to just the people in the courtroom might pose some real kind of safety issue? Will it distract participants in the proceeding? That's sort of a nothing burger one. That's rarely the reason why a judge is not going to let cameras in. Are the facilities adequate? Again, very rarely a problem, unless it's in Pima County. We have a few courtrooms that are really, really small. If those courtrooms were packed for some reason, you might say that the facilities aren't adequate to have a camera, but rare. Timeliness, we talked about that at the outset. Get it done at the right time. So, those factors are things the judge has to listen to, and has to listen to evidence about what those factors in. Argument itself shouldn't be enough. Unfortunately, sometimes it is enough, but it should be evidence on, for example, a witness talking about why the safety of so-and-so will be impacted because they're part of this group, and if they're on camera, this is what will happen. Again, good journalism. If you get in, the judge says fine, cameras are fine. I've had issues where the pool camera person, for whatever reason, decides to move the camera in the middle of the proceeding. Not going to be a great result usually with the judge. So, good journalism, good procedure will be fine. And just ask the clerk or ask the judge on a break. Judge, we noticed, I had this one come up recently. We noticed we can't film the witnesses at all for some reason from this angle because the defense attorney is making sure to stand up right in front of our camera. Would it be permissible for us to move the pool camera, during the break? Just ask. And many times, now that if the judge has allowed cameras in the first place, they're going to say, sure. Just don't do it in the middle of the middle of the proceeding, because that's not going to go well. No flashing lights, obviously. Most judges aren't crazy about even steady artificial light, and so generally speaking, that's not going to be allowed. The idea being that is a distraction. If a witness is sitting up there and there's a big light on them, they're not accustomed to that, and can be distracting. What do you do if you go to the courtroom? Forget about cameras, but you're just a journalist going to to take notes on some proceeding or hearing, and the courtroom is closed. There's some note on the courtroom, the proceeding closed. That does happen, but only very rarely. Those proceedings are presumed to be open. I would, first of all, pick up my phone right away. I'd call my director or manager and say, we're here for the, Johnson Smith hearing. There's a note, the door's locked and it says it's closed. What do we do? Usually the news director or manager is going to call the judicial assistant and say, this is what our person's experiencing, what's going on. Usually that won't happen. Judges are usually pretty good about notifying folks well ahead of a hearing that for some reason it may be closed. There can be a lot of reasons for that. Again, it's rare, but it can happen. Obviously, if you're in a courtroom and the judge says this part of the hearing is closed, and you refuse to leave, that's going to probably be a bad idea. I would leave, of course, and again, make that phone call and say, I was just told to leave the courtroom. I don't know why, if I understand it, can you, what do I do? Don't refuse to leave a courtroom. Judges are not going to. So public records, I said earlier, the photos is probably the second most common. I would say public records and getting public records is the most common call and email that I get. I would say 20 years ago, I rarely got these calls. In the last 15 to 10 years, all the time. And it's really unfortunate. So the statutes definitely, it's kind of sort of heavy reading, but probably interesting to read if you've never done so before. You can find them in 39.121.01. What in the world is a public record? The records that a public body maintains are generally going to be public records. There can be nuances that we don't have time to get into, but most of those records are going to be public. So the one that comes up a lot is journalists will call me and say, because their statute requires prompt response. What that means exactly under Arizona law is not entirely clear, unfortunately. I mean, there was one case, I think it was 135 days, that may have been more, that said that's prompt enough. I get that all the time though, well, it's been 30 days. It's been 45 days. It's been 60 days. Go ahead, Taylor.
Oh, no, keep going, keep going.
Yeah. What is a prompt response? And the answer is, I don't know exactly. It depends on the situation. I mean, if it's a very simple, document or small set of documents, and the journalist calls me and it's been 30 days, it's like, that's worth a call. That's worth a follow-up. Is it 45 days? Yeah, for sure. Let's start. Is it 60? Yes. So it's really dependent on the kind of request, and we'll talk in a minute about how to make a good request. And it depends on the number of documents and how thick they may be and how many different departments they may need to go to get them. But that can be really frustrating, and it happens all the time where they say, look, this story is not going to matter to anybody, in 3 months. I want to get this story done in a month. Mark?
Yeah, Peter, I recall when the prompt statute was being debated in the legislature, there was some very serious discussion about setting a time certain. But even what was agreed to at the end, as I recall, even those who favored time certain realized that unscrupulous or clever, depending on what you'd like to refer to them as, public servants, if the time certain was 30 days for a record that they could easily provide in 2, they would wait 29 days, 23 hours, and 59 minutes to give it to you. And they thought that there'd be more hanky-panky in that regard, that it would be worth it to set a time certain. So I guess the word prompt was left to the discretion of judges as to based on the type of record and the volume of it and so forth.
Yeah, and we'll actually get to the issue of judges and promptness in a second and explain what to do if this all falls apart
Yeah.
and someone like me has got to do something about it. But before we get there, let's talk about trying to get the public records request from the outset being such that we're unlikely or less likely to sort of run into these problems. So a lot of times I'll just sit down with reporters or journalists and write public records requests with them to sort of show them what I mean. But the first thing is to really sit down before you write down anything and think about, what do I actually need? Not the whole universe of documents that maybe I might want to look at, but what do I actually need, or where might the documents that I actually need be? Try to really focus. Focus is important because you want to tailor your request very carefully to get what you want. Be concise about it, and don't write like a lawyer. Write like a journalist. Use really good sentence structure. Use plain English. Don't use any legalese. Be really, really clean and clear. This is a good place to sort of flex your talents. And it should be so easy that if you gave it to any layperson and said, "What do you think I'm asking for here?" 9 times out of 10, they would tell you, "Oh, well, you're clearly just looking for this kind of, police report." And so be really, really concise, really tailor it to exactly sort of what you need. Taylor, do you have any sort of tips on what journalists might want to do when they formulate a public records request?
Yeah, I have a few. So, I know this is pretty standard practice, but inserting a date that you'd like to receive the records by, and then saying, if this cannot be met, please call me so we can discuss, potential alternatives, or, so that I can understand why. It's been helpful, and it also builds relationships because sometimes they're just being difficult, but other times there are legitimate reasons. And so kind of hearing them out and showing them that you're willing to hear them out really can build a lot of trust and just kind of get in their good graces. Another thing I do is ask for records on a rolling basis. So if I know that I've got, I don't know, 10 different documents that I want, or if there's going to be a batch of months worth, and I say, hey, if you could please provide, January 1st as it becomes available, and then February, and then March, because they might have to be going through redactions, but that way you can get things as they come, as opposed to waiting, months for the entirety of your records request. I will be honest and say, typically agencies just reject me for that. But I have found that by inserting that and kind of being really diligent and kind of warning them that, like, I'm going to be on top of this and I mean business with this records request, that it does tend to get kind of like light a fire under them to really fulfill the request. And then the final thing I would say, I learned this from a colleague and it has been tremendously helpful, is calling either the records custodian or the public information officer ahead of time and say, hey, I think I'm looking for this. You could frame it as like, does that sound about right to you? Or what do you think about this? And even if you know for sure, like, no, this is what I want, trying to kind of get them to feel like they're in on it and that they understand what you need, that, yeah, I do think that is, feeling like they are included in the process sort of builds an ally for you, where then if you're having trouble, you can go back to your person and say, hey, what's going on? I thought you've told me this was a good idea. Or you can ask them, like, what's a reasonable amount of time? That has boded very well for me, to be like, I'm thinking 10 days. Is that good to you? And then they say, I think 21. And I'm like, how about 14? It at least just creates like some sort of back and forth. And it also builds some accountability, where then you can be like, okay, hey, you're taking 45 and you said you were going to take, maybe 21. So that has been really helpful. I know we got a question in the chat about someone being stonewalled from the city of Phoenix. Story of my life for 3 years. um, that city is really difficult to get records from. So I know that it's not helpful retroactively, but like I said, the tips I just gave for the future can be helpful. Um, and then otherwise, just like truly calling the city repeatedly, and just being very kind but very diligent can help. And finally, as a last resort, at least in the case of City of Phoenix, they do not like negative press. So if you really have to, write a story about being stonewalled. Like, I know we hate to be the story, but again, I do think it's truly newsworthy. And I think the public actually does care to know when your government is not giving you information that like any person would want, whether it's potholes or red light camera running data. If there's a compelling reason to request the record, then there's a compelling reason to report on not getting it, I would think. So that's my advice.
So all really good points, 3 in particular that I really like. So one is the idea of giving some sort of date. 2, hey, give me a call. That's sort of the beginning of the thing I like the most, which is building that relationship. That can be critical. There was a reporter that retired about a year ago, really well known in Tucson, had been around, I think, almost 45, 50 years. She was terrific. She's a TV reporter, and she had relationships with agencies where she would get public records so quickly it would sort of make your head spin. Where another reporter, they would be like, I've been trying to do this for 2 months. How did you do this? It was because of relationships. So that's really important. We're getting there, but I saw one question about being stonewalled by the police. What do I do? Unfortunately, that's usually going to end up with someone like me, because there are legal reasons why things like, and I see this all the time, even in my private practice. Oh, well, we can't give you the records. It's an active investigation. Okay, that's fine. You can say it's an active investigation, but that doesn't eradicate your duties under the statute to properly respond. And there's all kinds of ways to respond to when you get these letters from someone that they candidly either don't know what they're talking about, or as the person, I think my eyes aren't that great, Jerry said, getting stonewalled. Those are tactics, unfortunately, that can be used. Most of the time, they're gonna have to be defeated by a lawyer writing them back and saying, this is why you're wrong. And more importantly, if you don't do it, this is what we're going to do. And that is file a statutory special action against you. I love those. And a statutory special action, I get to go sue the agency for failing to do this. And you want to talk about your head spinning and getting the records quickly. A lot of times those never go anywhere because they get served with that and get the records. It's unfortunate that a journalistic entity has to hire their station lawyer and pay them to go do this when they should be able to get them themselves. But it often results with that being necessary. Federal's not that much different. It's probably, since we're running out of time, I won't talk about it, but those are FOIAs as opposed to Arizona public records requests. Remember, they're different. They're totally different statutes. There's some moderate differences, which maybe we'll talk about during some other seminar. I usually say the last thing, which I'm going to say now, after I do, let's say, a whole day, a seminar or a couple day seminar with a particular station or group, is look, I know we covered a lot of information. And if you really don't remember much of what we talked about tonight, tomorrow, or next week, or next month, I really, and I believe this so strongly, if you really use good journalism in so many of these things, it turns out that using good journalistic technique happens to be the right thing to do when it comes to either the statutes or the cases or the rules. Using good journalism will often get you out of problems before they happen, or be a great defense if something does happen and someone like me has to get involved. Taylor, you have any sort of closing thoughts on the materials?
No, I noticed that Eric is in the chat, and he was he worked in economic development at the City of Phoenix, and he was talking about how, I used to tell reporters to just call me and ask for the records, so that I didn't have to go through the bureaucratic process. And yes, it was the best. When Eric left, I was so sad. So it is great. If you can have sources like that, it is incredible. Because think about it from kind of the city officials' perspective, it is so many layers of bureaucracy that they have to go to simply to provide a record to a journalist. That's very easy. It might just be on like a folder on their desktop for them. Unfortunately, the sad thing is, at least in my experience, both at the city of Phoenix and other places, staff is, I find, increasingly scared to break the rules. And I say rules pretty loosely, but you know, so Eric was a gem.
Yeah, no, having someone like that, and that's the kind of people that this reporter I mentioned earlier had. And that can be really valuable. And look, I mean, there do have to be systems in place for public entities because unfortunately, there are some people, rarely a journalist, thankfully, but there are some people that can be abusive to public records requests, and that can create a huge burden for a public entity. Fortunately, that doesn't happen a whole lot, and I can't say I've ever seen, at least myself, I have never seen a journalist, certainly in Tucson or Phoenix, engage in that kind of conduct, and I would be astonished to ever see that. But those relationships are really critical.
I think we'll be able to stay a little, if you'll all indulge me, we'll stay a few more minutes afterward. Tim has a couple of questions from our attendees to ask.
Yeah, thank you both. Phenomenal. One thing I'll say quickly, and I'd like your thoughts on it, is if you are seeking a public record from an agency that's controlled by state statute, and they are limited to what they can tell you by state statute, I'd recommend getting to know that statute really well to figure out what they can tell you and what they can't, because it really helps. So I'll just mention that.
Yeah, no, absolutely.
Yeah. So I'm going to go back to Tom Bodis's question, who said, we once had a town government accidentally give us a recording of an e-session. When they found out we had it, they wanted it back and threatened legal action if we used it. What's the obligation there for a newspaper to return it or suppress the information?
So I think,
Isn't this what emerged out of Colorado versus Bryant? Do you remember that case of the Kobe Bryant case where the clerk's office accidentally released transcripts of testimony of something that they weren't supposed to? The media got a hold of it, and it went to the Colorado Supreme Court. Just that aspect of the case.
And what was the result?
Very interesting divided decision. The media was entitled to keep it, but they couldn't use it. That was the decision.
Yeah, and so
they were not to be held responsible for not giving it back, but they could not use it.
So similar things have happened where I've had a reporter say, so and so gave this to me. I have no knowledge that they obtained it in some illicit fashion. You know, can I use it? The answer is generally yes. In the question that was given, I would advise the journalist to have them state in writing what the legal basis for us having to return something that has been provided is. That's sort of the safest way to start that process, because I think the end result of that is going to be, unless there's a court order, the journalist is going to be able to probably use it.
That's interesting. And I think, Taylor, you might have met in a recent story you did where you mentioned several cases. Did you mention Bartnicki versus Vopper? The one about the somebody had just by accident recorded a cell phone conversation that just happened to go that they were driving along, and the radio waves just happened to get them. And it was some people who are conspiring to kill a school board member or two in this community over something. And it was provided over the transom to the media. The media published a story about it, and the participants in the recording were aghast and sued over it. But was that in your story?
Yeah. Yes, that was in my story. Yeah, I was basically just establishing the fact that, you know, courts have ruled that if you get information, even kind of in not legal ways, but you didn't do the one that was like breaking the rules, that you are still allowed to publish that, and you're kind of okay and within your right, as long as you weren't actually engaged in the criminal activity yourself.
Yeah, that you didn't instruct them. I mean, that's the
Right.
point. You can't instruct someone else to do what you could not have done and say, oh, it was them. But if they give it to you, you don't have any direct knowledge of, something, you didn't participate.
It was also one of the most, poetic, for lack of a better word, case names in American history, Bartnicki versus Vopper.
So let me ask you this, and I think I know the answer, but maybe not. Much of this discussion has referred to legacy media like newspapers and TV stations, says Jerry Copel. One of my main clients is a small, scrappy startup with 2 full-timers. The rest are freelancers. What do we do if we need legal help? I mean, I assume if they're practicing journalism, Peter,
Call
they
me.
can still call you.
Of course. And in fact, those are a lot of the calls that I get, where it's candidly, probably maybe something I've never heard of before. But I don't care if it's the Arizona Republic or, some TV station. I mean, the same issues and the same passions apply. I don't want anyone, regardless of who they work for, if they're journalists, I want them to call me. And I'm no less passionate about a smaller operation than I am a big one.
Excellent.
And
And
here's
I would urge people, since Mark put up this beautiful, I feel like I'm at the drive-in when the advertisement, the PSA comes up, but people should screenshot this or take their phone out and take a picture because it's important. Go on, Mark. Sorry.
Well, anyway, here it is. There's this Peter's email address, and there's his phone number. That's the phone. That's the number of your firm. So call and ask for you.
Yeah, and usually what will happen is I may or may not directly pick up. If I don't, for some reason, my assistant will pick up, and so I'll get a message from her by email immediately saying, "Hey, someone has a First Amendment coalition, question. They work for so and so. This is the issue. So if you can just be really concise and explain what the issue is, and then second, and really important, some of these things are time sensitive. Obviously, we've talked about that tonight. They're in the meeting now, that sort of thing. And if it's possible, they'll be able to pull me out of whatever I'm doing. So timeliness, how important it is that it be answered quickly is also important.
That's terrific. Thank you.
Well, I sure. Oh, go ahead.
Anything else, Tim?
No, I was just going to say thank you both. This is phenomenal, and based on some of the comments I've seen and received directly, I think this is important stuff, and perhaps we do something on covering courts in particular in the future. We'll see.
That sounds good.
Well, good. Then we'll wrap up here, and I'll ask our panel and Tim to stay on after the call's over when we say goodbye. But I want to close by saying thank you, Peter and Taylor, for your insights this evening, and a reminder again to Arizona journalists, whether you're a professional or a student, Peter will answer your basic questions about access to government in areas such as public records and meetings, cameras, electronic devices in courtrooms and the like. It's not just cameras anymore, but tablets and phones, and when you can use them and when you can't, and how you can use them. By contacting again on the hotline. We started out as a hotline where you called. Now we added email in the 21st century. The coalition's been offering this advice to journalists since 1981. So it's your turn, everybody. And here's the contact information. Again, this session has been recorded, will be posted at a later date, and Tim has compiled all of the great URLs of all the, in real time, he was finding all that during tonight's discussion. We will post them on the chapter website, which is phoenixspj.org. And we'll also send out a post-event email to everybody who signed up for tonight's discussion that will contain them as well. So if you didn't grab all those URLs, we're going to send them to you. SPJ is the oldest organization of news people in the country. It was founded in 1909 by a group of college students. They were seeking to elevate the standards of the journalism profession. We're still doing that today. Our Valley of the Sun chapter was chartered here in Phoenix in 1958. So if you like us, please join us. Find out more about SPJ, our events, our activities, and how to become a member at phoenixspj.org. With thanks again to our panel I'm Mark Scarp. Have a very good night, everybody. Thank you again.
Thank you.